Pvl2602, the specific duties of the executor. Number 1, he must take personal possession of all assets and documents related to the estate. Take personal possession of all assets and documents related to the estate. Number 2, draw up an inventory of estate assets and he must state the value. Draw up an inventory of estate assets and he must mention the values. An executor that sells assets not in the inventory commits an offense. An executor that sells assets that are not in the inventory commits an offense. He must ascertain who the creditors are and get them to submit their claim. He must ascertain who the creditors are and get them to submit a claim. This can be done by advertising in the Government Gazette and in another newspaper. It can be done by advertising in the Government Gazette or in another newspaper. He must assess insolvency or otherwise of the estate. He must assess solvency or otherwise in the estate. Open a bank account in the name of the estate as soon as he holds 100 Rand or more of estate money. He must open a bank account in the name of the estate as soon as he holds 100 Rand or more of the estate money. He must liquidate the estate, sell sufficient assets to pay the creditors, and may not sell more except with the permission of the master. He may not sell more of the assets other than to pay the creditors. The liquidation and distribution account lists all assets together with valuations including fiduciary assets. The L&D account lists all the assets together with valuations including fiduciary assets. Together with the valuations including fiduciary assets. All creditors with full details. This account is sent to the master for approval and must lie for public inspection. Section 35 and advertisement of account in the Government Gazette and of another newspaper stating account is lying for inspection for a period of 21 days. When account lies for inspection and no objections, the executor must pay creditors and beneficiaries in the estate according to the account. If the executor is unable to pay funds to beneficiary within 2 months after finalizing the account, repeat, if the executor is unable to pay funds to beneficiaries within 2 months after finalizing the account, he must use these funds to the master, who will keep it in the guardian's funds. In other words, he's got to pay money to a beneficiary, but it can't be traced, so it will be transferred to the master and is kept in the guardian's fund. After the executor has performed all his duties, he is entitled to discharge. After the executor has performed all his duties, he is entitled to be discharged. He is entitled to be discharged. Collation. Collation is the principle according to which the executor of an estate must, under certain circumstances, take benefits given to certain heirs of the deceased during his lifetime into account when distributing the estate amongst other beneficiaries. So in other words, whilst the testator was still alive, he gave certain assets to certain people, and this must be taken into account. This must be taken into account by the executor of the estate. Collation is based on a presumption that parents wish to treat their children on an equal basis as far as succession is concerned. Who must collate only takes place in the direct line of descendants. This is deceased children and their children. Person who collates has the choice of collating goods or their value. Who must collate, repeat, who must collate, only takes place in the direct line of descendants. It only takes place, this is the deceased children and their children. A person who collates has the choice of collating their value. Benefits that must be collated. Benefits received as a child as part of his inheritance. Benefits received for the promotion of the child's occupation or business. Benefits given with the view to marriage. Benefits given with a view to marriage. Repeat, benefits that must be collated. Benefits received as part of his inheritance. Benefits received as part of his inheritance. Benefits received for the promotion of the child's occupation or business. And benefits given with a view to a marriage. New developments. This is now on page 15. The influence of the Constitution on the law of succession. The influence of the Constitution on the law of succession. Intestate succession. Section 14B of the Intestate Succession Act granted that an estate intestate estate included any part of an estate in respect of which Section 23 of the Black Administration Act 38 of 1927 did not apply. In other words, Section 14B excluded intestate estates that were subject to the Black Administration Act from the operation of Intestate Succession Act. The Black Administration Act was accompanied by regulations for the administration of the distribution of estates of deceased blacks. This parallel system of intestate succession, set up by Section 23 and the regulations purported to 36, give effect to the customary law of succession. It prescribed which estates were to devolve in terms of what the Act described as black law and custom, and described the steps that had to be taken in the administration of those estates. Central to the customary law of succession is the principle of male primogeniture, in terms of which the eldest male of the head of the family is the heir. The women generally do not inherit in customary law. In the Bahe case, BHE case, the constitutionality of Section 23 and its accompanying regulations, and the rule of male primogeniture was attacked. The Constitutional Court held that this Section 23 was unconstitutional, being contrary to Sections 9 and 10 of the Constitution because of its blatant discrimination on the grounds of race, color, ethnic origin, and its harmful effects on the dignity of persons affected by it. The discrimination could not be justified in terms of Section 36 of the Constitution. It was accordingly held that Section 23 had to be struck down. The rule of male primogeniture, as it applied in customary law to the inheritance of property, was also held inconsistent with the Constitution and invalid to the extent that it excluded or hindered women and extramarital children from inheriting in the property. The court was of the opinion that the legislature was the appropriate forum in which to make the adjustments necessary to rectify the defects identified in the customary law of succession. Repeat, the court was of the opinion that the legislature was the appropriate forum in which to make the adjustments necessary to rectify the defects identified in customary law of succession. The court held that an interim solution under the legislature adopted the necessary legislation. Section 1 of the Intestate Succession Act should be applied to all intestate estates. This could be done by ensuring that Section 11CL and Section 14F of the Intestate Succession Act, which made provision for the child's share in the single surviving spouse and manner of calculating. This made provision for the child's share of the single surviving spouse and manner of calculating the share should apply to the three qualifications if the deceased was survived by more than one spouse. A child's share in relation to the intestate estate of the deceased should be calculated by dividing the monetary value of the estate by the number equal to the number of children of the deceased. Repeat, a child's share in relation to the intestate estate of the deceased should be calculated by dividing the monetary value of the estate by the number equal to the number of children of the deceased who have either survived or predeceased such deceased person but are survived by their descendants, plus the number of spouses who have survived such deceased person. Repeat. A child's share in relation to the intestate estate of the deceased should be calculated by dividing the monetary value of the estate by a number equal to the number of children of the deceased who have either survived or predeceased such deceased person but are survived by descendants, plus the number of spouses who have survived the deceased person. Each surviving spouse should inherit a child's share of the intestate estate or so much of the estate as does not exceed in value the amount fixed from time to time by the Minister of Justice and Constitutional Development by notice in Gazette, which is 125,000 Rand in present. Repeat, each surviving spouse should inherit a child's share of the intestate estate, also much of the intestate estate as does not exceed in value the amount fixed from time to time by the Minister for Justice and Constitutional Development by notice of in the Gazette of 125,000 Rand, which is at present. Notwithstanding the provisions of subparagraph B above, where the assets in the estate are not sufficient to provide each spouse with a fixed amount by the Minister, the estate must be equally divided amongst the surviving spouses. Repeat, notwithstanding the provisions in subsection B, subparagraph B, where the assets of the estate are not sufficient to provide each spouse with the amount fixed by the Minister, the estate must be equally divided amongst the surviving spouses. The effect of Behe decision on the law of intestate succession. At present, there is only one act, namely the Intestate Succession Act, which regulates the devolution of all intestate estates. It regulates the devolution of all intestate estates. Behe amended the calculation of a child's share when a deceased is survived by more than one spouse. When a deceased is survived by more than one spouse, this amended the calculation of the child's share, in that the child's share would be determined by adding all the surviving spouses, i.e. not plus one, but plus the number of surviving spouses. Page 16. The meaning of survivor and spouse in the Maintenance of Surviving Spouses Act 27 of 1990 and Intestate Succession 81 of 1987. Repeat, the meaning of survivor and spouse in the Maintenance of Surviving Spouses Act 27 of 1990 and Intestate Succession of 1987. The Intestate Succession Act is discussed in Chapter 2 of the Study Guide, and the Maintenance of Surviving Spouses Act in paragraph 9.1.4. In terms of Section 1 of the Maintenance of Surviving Spouses Act, a survivor is defined as the surviving spouse in a marriage dissolved by death. The survivor is the surviving spouse in a marriage dissolved by death. The Constitutional Court had to decide on the meaning of spouse and survivor as used in the Maintenance of Surviving Spouses Act in relation to Muslim marriages. See Daniels versus Campbell and Hassam versus Jacobs, and persons living in a permanent heterosexual life partnership, example Folks versus Robertson. Folks versus Robertson. So let's just repeat that quick. The Constitutional Court had to decide on the meaning of spouse and survivor as used in the Maintenance of Surviving Spouses Act in relation to Muslim marriages, which is the Daniels versus Campbell, as well as Hassam versus Jacobs, and persons living in a permanent heterosexual life partnership, Fawkes versus Robinson. The meaning of these words are used in the Intestate Succession Act, also came up for decision in respect of Muslim marriages and persons in same-sex life partnerships. Daniels versus Campbell. In this case, the applicant has been married to her husband, the deceased, for 30 years.